Good evening, everyone. Present over here, I am Kanak Batwal, moderator of today's workshop on ADR, organized by LawInternships, the online law school. LawInternships, the online law school, started off with a vision to help any law student achieve their dream internship with top-notch lawyers, law firms, corporate bodies, and such. Today, we provide opportunities in the field of law to the students pursuing undergraduate and postgraduate programs as well. We assist students at every turn to gain professional experience as well as to hone their legal skills while being enrolled in a full time program. It gives us immense joy to see that our mission to pave a path for the young lawyers to be is becoming gradual and steady. We are happy to see students who have approached us are placed under able mentors. With that, we also take pride in our vision for a full fledged online law school which shall provide extensive education services. The objective is to forge a credible platform for the law aspirants who want to pursue and fulfill their educational requirements, wholesome with the practical exposure to the relevant skills. Further, I welcome our speaker of the session, Tushar Belser, who is an advocate based out in New Delhi, India. He is currently working in dispute resolution practice of LNL partners and specializes in international arbitration as well as civil and commercial litigation. Prior to joining LLL partners, Sir has worked as a legal consultant at the Supreme Court Committee on Road Safety, Ministry of Road Transport and Highways, Government of India. Sir has also worked with Justice Abhay Manohar Sapre, Supreme Court of India, as his law researcher in arbitration. Sir is a graduate of the School of Law UPS Dehradun and has also specialized in the dispute resolution pathway of the Daksha Fellowship, India's first residential fellowship program for young and mid-career lawyers, public policy professionals operating at the intersection of law, technology, policy, and business from Sai University, Chennai, India on a full scholarship. Now, taking the session to the next level, I would like to brief about the rubrics for the today's workshop, which are as follows. First, we would be addressing and understanding the transforming conflicts. Second, the difference between the adversarial and problem-solving approaches to negotiation. Next, we will learn about Batna, Vatna, Latna, and Zopa. Next, we will learn about the 6 thinking hats. Next, Impasse. Next, we will also learn about information gathering, power, rights, interests, positions, and options. And lastly, we would be knowing how to deal with difficult and hardball negotiators. If anyone has any queries or questions, you can raise your hand and we shall recognize you and unmute you. And in the very end also, the floor shall be open for any questions. Without delaying any further, let's begin the workshop. Over to you, sir.
Yeah, thanks, Kanak, for such a warm welcome, and welcome everyone. Good evening. Kanak, if you could share your screen with my presentation.
Yes, sir.
Okay, next slide. Next slide, please. Okay, so I assume that all of you are participants in this mediation competition organized by LawInternships, and those of you who are not even the participants, you might be aware about the term ADR basically. So ADR is often used to describe a wide variety of mechanisms. We have mediation, arbitration, conciliation, negotiation as the primary ones that when we talk about ADR in India. So ADR is basically settling a conflict out of court. Now, why do I not call it a dispute and why do I call it a conflict? So basically conflicts, there are 3 stages to define what a dispute or what a conflict is. Two parties taking a hypothetical example, 2 parties have basically disagreement over a certain issue or a certain thing. These disagreements are further on elaborated by both the parties when they come with their inputs and informations. These escalate into conflicts. If a conflict is not resolved by way of mutual understanding by talking to people about it or elsewhere, they escalate into dispute. So that is a dispute. And this is the reason why we call this mechanism as conflict resolution first and then dispute resolution, because dispute is a very heavy word, and that is when things escalate, and you shouldn't actually call it dispute until it's a actual dispute. So basically, four mechanisms are there to cover all these conflicts and disputes which arise out of court, basically, out of which conciliation, mediation, and negotiation, as you are all aware, is outside the court entirely. Arbitration involves lesser or little interference, but there are court interferences in arbitration. We have Lok Adalat as well in the form of an additional ADR mechanism, and now we have certainly many more ADR cells promoting online dispute resolution, which have other mechanisms as well. So characteristics basically of ADR approaches we'll come down to in the next slides, and I'll explain them in detail. But of course, today's presentation would be revolving around mediation and negotiation, basically, because this is what the competition entails and this is what the mechanism involves. But of course, a lot of which today I would be saying would be based on real life situations and taking into competition perspective into picture. Next slide, please. Kanak, next slide.
So is the next slide visible?
No. Yeah, just move it that way. No need for a full screen view. That's okay. So conflict transformation, conflict resolution, all of these things are, from a society's perspective, it is about rights and obligations and the relationships in a social structure that we have through basically spheres of human rights, non-violence as a way of life. To understand disputes, it is very understandable to, think about what a conflict is and how do conflicts transform. As in the first slide I was explaining, because if you have a certain disagreement with a person, you can actually met it out and you can actually resolve it by way of talking to each other.
चलो यार तुम भी यार
चलत है अब्बर नानचू खास
हैं
चल
चलो वांस कितने पट्टे आपने
7 4
Can you unmute this, can you mute this participant or kick him out, basically? Yeah, thanks. So basically, as I was saying, yeah, we have certain disagreements, and these escalate into conflicts. What one can do is basically talking over about that particular disagreement in a in a way that your interests align, both of your interests align by talking to each other. That is basically a form of negotiation that we have. Like, there are two parties involved sitting on both the sides of the table and talking to each other. It's a direct form of conversation. So basically that's negotiation. Transformative mediation, of course, mediation is something where you cannot actually resolve a dispute by way of direct talking and mutually understanding, and then you appoint a neutral who will be taking care and helping your parties to actually resolve that conflict. That's basically mediation. So in the end, I mean, entirely all of these mechanisms are alternate dispute resolution mechanisms, but of course it is it is of utmost importance that you get through them and you participate through these mechanisms first, because of course these are time efficient and cost effective, and in the end resorting to adjudicatory means and even arbitration and litigation entails certain amount of time, certain amount of efforts, emotions, and everything comes into picture. So basically conflict transformation in the sense is basically a very broader concept, and it is very much important to understand all of these before we jump to mediation. Next slide, please. So there are various approaches as to how you resolve disputes or conflicts between each other, and there are two major approaches to that. One is the adversarial approach and the second is the problem solving approach. In the end, whatever I say today, all of these are personal to every person, and you have a certain way of resolving a conflict or dealing with a particular issue, that is different to every person. So these are the two most common ones that you should be aware about, and you should assess within whether you actually have these approaches or not. So adversarial approach is basically where there is harsh behavior on part of both the parties to win that particular thing overhand and to win that particular argument. It is an approach to that sees negotiation basically as a combat, wherein you have the other person in front of you, and you think that based on whatever power you have or whatever you can pressurize the client, and we win that situation. You do not have that win-win situation in the mind, and you are not concerned about the other person. That itself leads to a stiff competition when it comes to negotiations. A problem solving approach is basically a more collaborative approach, wherein you think about the other person, you have empathy within yourself, and you see it as a relationship building exercise and not to end that relationship with that particular person. So in this approach, basically this is the approach that ideally every negotiator should follow, to think about that other person on the table, to get into his or her foot before understanding, to understand all those situations in which the other person is going through. And that's how you should actually negotiate further, to understand everything, to understand both the interests, and then create a win-win situation which is mutually beneficial to both the parties. So in this, basically negotiators should actually work together in terms of communication, have a clear line of communication, have a clear set of understanding, wherein both the parties are actually talking about what they felt, how they felt, how is this issue particularly important to that particular person, and how these commitments, how they want to save that long-term relationship into picture. So that is the most important approach. And the problem solving approach, basically, as I said, focuses on underlying interests rather than positions. So the difference between positions and interests is that a position of a particular person so as to a particular situation is whether or not that person has a way forward from that situation, or how he or she is dealing with that situation. But underlying interests know that to your positions cannot be actually differed in a way, and your positions cannot be uh, have a negative impact on yourself if you have certain kind of options available with you. So it's very important to have that interests in your mind, that if that other person's interest is suitable to mine and my position is not at all affected by that, why not focus on these underlying interests and then proceed forward to the negotiation. So with this problem solving approach, you actually have that friendly nature in the negotiation, in the negotiation room, and there is a happy environment and there is a comfortable environment when it comes to trust building, relationship building, and all of those things. So rather than the other party backfiring or disagreeing with all of your situations, if you adopt a problem solving approach right from your end, these things help a lot when it comes to negotiations. Next slide, please. Bhatna, Vatna, Mlatna, and Zopa. These are the four most important things when it comes to an ADR process, typically a mediation and negotiation. So Bhatna, as you would understand, is the best alternative to a negotiated agreement. That is basically the course of action that a party engaged in negotiations will take if it fails. So you already know that if you negotiate this thing, this is a certain benchmark that I can't go beyond. And this is the likelihood of that particular situation where no agreement will be reached. So basically, these Bhatna is very much, all of these four processes and all of these four concepts are irrespective of that particular person, and these are not common to both the parties. Everyone has a different Bhatna, and this can be adduced from the problem itself, that what if no agreement is being reached after making an effort for 45 minutes in the negotiation session. So every party is aware that this is the thing that if the party reaches, if the parties fail, and we can't actually negotiate and reach to an amicable settlement, this is the best alternative that I can have out of this, or and I need this thing in my hand. So basically, this is the best alternative that parties are aware. So example, if there is a dispute of like $500,000, and there is a breach of contract and everything that's going into picture, the party is not able to pay that amount and he or she is being very much adamant that we won't pay and these are hardball negotiators, what would be your best, your partner would be typically to have a specific performance of the contract, that if you guys have entered into a contract and the payment cannot be given back and the damages cannot be given back, at least you can aim for a specific performance of the contract and enable that particular party to actually perform his or her due obligations. So basically this is the best alternative you can have if you reach the negotiation stages, you complete those negotiations, you fail. But the negotiation process fails. The worst alternative would be basically that in this particular situation, if we have that contract issue going on, which I've talked about, and your partner in this case would be that you guys just settle amicably and there are no damages being paid. You just settle the contract charges and there is no specific performance as well. You just have another subsequent contract with another party, because this is the worst alternative. You are not even getting the damages, you are not even getting the obligations performed by the other party. So if nothing is going on into picture, Vartna will basically provide a benchmark that the settlement offers can be evaluated against. So both are unrealistic in that sense that both of these, Vartna and Vartna, are very much distinct from, but both of these things should be considered by the parties, because there are always good likelihoods that a negotiation can fail, because in the initial session it is very difficult to settle. So you should always keep in your mind what is your partner, what is your partner, what are the worst case scenarios that we call. It's basically partner. Latna is basically the most likely alternative to a negotiated agreement. So it is basically a probability that you have already in mind before going to a negotiation. And uh, this is something that you already are aware that, there are 100% probability, or there is some probability that the party would be able to give to you. And this is something that I really want to achieve. So this is also something that you need to take care about, that rather than focusing on those tactics and everything, you just focus on the benchmarks against which offers to settle can be evaluated. So with all the solutions and options which are being put on the table, you actually take care and evaluate every possible solution to actually see what is the most likely alternative to a agreement. And this is, of course, this cannot be predetermined. You just keep in mind what's the probability, but this is actually something which actually gets evaluated in the negotiation session where both the options are put on the table. Zopa basically is called the bargaining range. It is not any it is not any alternative. It is a basic line where there is a potential agreement that would benefit both the sides. So Zopa, or the bargaining range, is, of course, you can deduce that from the confidential informations, and it is the most critical thing in the negotiation competition or any real life negotiation, because Zopa is that possible zone where you reach that, if there is a solution that both the parties are suited to and both the parties can be benefited against, that's basically your zone of possible agreement. Then is the time where, when you catch hold of the Zopa, then is the time you should actually propose that solution and, settle right there. Because Zopa is something that if you are aware about Vatna and Latna, and even after all of those situations, you come to a point where both the parties feel that this is something good for us and this can resolve this particular conflict. That is your zone of possible agreement, and that's where you actually should make the settlement. So yeah, next slide. Six thinking hats. Basically, these thinking hats are also important from a negotiator's perspective, and everyone has a different thinking hat. None of these hats are, particular to any person, and none of these are mandatory to do, but these are what have been established in various negotiations that have been taken into place. So it is more about, the thinking hats are more about, not about your thinking, but your perspective that you have as a person initially while going for a negotiation. But that perspective is also in a conflict free way. So you are not clearly talking to a party right now, but you're thinking before the negotiation starts that, this should be my strategy, this should be my conduct during the negotiation, I need to be too formal, I need to be aggressive. All of those things that you have is basically the perspective that you hold. These are the 6 thinking hats. So the blue hat basically is called the conductor's hat, where you actually where you are not submissive, but you are actually controlling, thinking rationally, controlling your thoughts. You are managing the decision making process, you are taking the lead, you are not actually being uh, hardball, or you are not pressurizing the other client, but you are actually taking control of the process and leading the way forward. That is a collaborative approach only. The green hat is basically the creative hat. So where there is Batna, where there is Vatna, and there are situations where there is no agreement being reached, you find out creative solutions and think on the spot. This can also be done if you think beforehand the negotiation, but creative hat comes into picture when you are actually thinking on the spot and thinking for both the parties, and explore multiple ideas, put it on table, multiple possible ways to actually reach to a settlement agreement. That is the green hat. The red hat represents feelings and instincts. So basically, if you are that kind of a person, you can express your feelings without justifying them logically. So this usually happens in mediation problems or negotiation problems where there are huge rights and feelings involved. So for example, if there is a situation wherein the farmers are being their land has been snatched away for some industrial purpose and for some construction, there the farmers have that red hat, they have those feelings and instincts about that particular land they have and the crops they grow, so they can justify, without justifying, they can express their feelings. That is basically the red hat. Yellow hat is basically a hat of thinking. You look at issues in a positive way. So you have positive affirmations. Even if a situation is going wrong, you find positivity in that thing, and you can convey it to the other party that this is how this situation needs to be resolved, or this is how this needs to be taken into picture, and this is how we can actually change the scenario of that. So despite all the negativities, a positive attitude is always essential. So you have that yellow hat. The black hat is always about being cautious and assessing what are the risks, what are the drawbacks, what are the disadvantages, what are the advantages. You are a rational person here, where you take every step bit by bit, and you take every step after thinking, after talking to your co-counsel, after talking to multiple people, and thinking over everything without saying yes. So that is another type of personality. The final one is the white hat, which involves information gathering. You basically dwell upon everything to take out and extract from the other party, ask them multiple questions, clarify if there is a certain issue going on, and you assess everything, you gather all the information, and then you come to a solution. So all these are not different to a person, but everyone has these hats. This is the ultimate scenario when we talk about 6 thinking hats. Every person has that. All these 6 thinking hats are there in every person, but the ultimate goal to winning a negotiation is basically using these hats at appropriate intervals, at appropriate places of time, being adjustable to a particular situation, and adapt to a particular situation by way of using these hats. So yeah, next slide. Impasse. So impasse is basically a deadlock in mediation, wherein neither party is willing to compromise on any of their interests or any of their positions. Parties usually reach this situation when they are likely to regard it as the end of negotiations, after making too many efforts, and after doing everything they can in a positive way. They think that nothing is happening and mediation is not meant for me. This usually comes in real life situations, and in various cases out of 100 cases, if I would give an example, 75 to 80% of the situations where there will be an impasse and parties would get out of the room, they would shift the table, they would tell the mediator that this is not working, they would fight, and all of these happen. So I'll also talk about how to avoid this situation of impasse. But before that, there are 3 types of impasse here. Emotional one is where the party is emotionally stuck on a particular situation, as the name suggests, and they have a certain level of emotion attached to it. So going back to the previous example of a farmer's situation where their land and their crops have been destroyed by a certain construction company, they would be, of course, emotional about a lot of things because everything has gone into stake and they are being asked to move to a different land where they need to start all over again. So there are situations in these critical negotiations and very delicate negotiations where emotional impasse can be taken to picture. That is, of course, impasse is not a negative situation, but it is a situation where both the parties, after doing a lot, they can't reach to a situation. A substantive impasse is basically in terms of resources, basically tangible things, going on principles and all of those things. So substantive impasse comes into picture that point of time. Procedural impasse is when either of the parties actually say, as I said before, that they say that mediation is not meant for us, or we do not like this process, this is very unfair or inappropriate. So all of these reasons, impasse can take into picture. Next slide. What are the techniques to basically cut down an impasse? So reality testing or reality checks. Basically, this is the most important thing that you can do in a negotiation competition. Or, even mediators can do this, even counsels can do this. Even the clients can do this. Reality testing is basically, asking questions, discussing the strengths, weaknesses, drawbacks, advantages of a particular issue that is being discussed, and thinking over, going back to that particular point and seeing that is there any possible way that you can actually get this solution on board. So for example, if there is a problem where there is a breach of contract and the damages are to be paid, and if a party proposes that out of $500 million I'll pay $250 million, reality testing comes into picture. Whether when you ask that particular person that question, that how will you pay that particular money, what are the ways in which you will pay that particular money, do you have certain kind of resources to pay for that $250 million? That is the reality testing. You basically ask questions to the other party, get an understanding of whether that particular party is ready to perform that obligation and by what means. Reality checking is basically that. Brainstorming is another technique used to generate options, basically. So focusing on underlying interests, as I already talked about, and acknowledging and complimenting the parties for their time and efforts. Because certainly if you are in 45 minutes of a negotiation session, all the parties have devoted much time and much emotions into this and efforts into this process, and you need to make the other party aware that we have spent a lot of time on this process, and we shouldn't go empty handed. Both the parties should actually endeavor to get at least one thing from this process which is beneficial to both the parties. So you need to keep reminding all these things where impasse happens. Role reversal is basically being empathetic and understanding a particular or your opposite party's situation by going to their foot and getting into their shoes, understanding what actually that other person is going through, understanding his or her feelings, and basically trying to understand what that particular person has in terms of perception. Changing the topic. So if you have 3-4 issues which are being sorted out, and one of the issues is, the first issue is not being settled and there is a huge wastage of time and effort there, you can shift to the next issue and come back to the first issue again. Using hypothetical situation on questions. So when it comes to impasse and there are certain alternatives which are being put on table, and a party is not sure whether to accept that particular situation or not, you give a hypothetical example to that party and test that solution. So in terms of the earlier example, if you are ready to pay $250 million for a breach of contract, you just consider that you give an example of a bankrupt company and say, your company is also low on liquid cash right now. So giving an example of a bankrupt company, you will say that, you can sell your assets and stuff like that to pay me back my money. And that is how you come to the picture and create an hypothetical situation that, this is the reality testing and you are clearly in no situation to pay anything. But what you can do is you can sell one of your assets and, pay me back. So these are situations where you can use. Holding hope is something that, you know, every party takes into consideration that the other party would accept my proposal. So there are many techniques to cut an impasse, but of course the most important is reality testing and, you know, role reversal, to be precise, to actually understand, be empathetic enough, focus on underlying interests, and, you know, creating possible avenues for a settlement. Next slide. So there are three principles, as I am already talking about. These are three principles and procedures which needs to be taken care of while negotiating. One is the interest-based negotiation, which is the most important one for everyone and which should be followed despite any of your roles or whatever situation you are in. This approach basically shifts the focus of the discussion from position to interests, as I already talked about. Interests are the most important thing that you need to understand as a party from your other side's perspective as well. Basically, to listening to what they want, what they are here for on the negotiation table, creating a range of possibilities and creative solutions to, you know, help them reconcile and, you know, not reach that stage of an impasse. So therein, techniques such as effective communication, rational thinking, asking constant questions, reality testing, and all of these things into picture. And, you know, the most important thing here is to build relationships. So you need to be make aware the party, you know, you make them aware that this is the time and effort that we have devoted. This is what we are here to lose if we do not agree to a particular situation. So, you know, you need to focus on all these interests that the other party has, generate options for mutually acceptable solutions, and later on convert these options into solutions. Rights-based negotiation is when, you know, when parties negotiations are failing and the parties can resort to uh, means which are not really effective, in the sense that, you know, this means appealing to the court, resorting to litigation, or, you know, forcing the other person or dominating the other person and telling that telling them that, you know, I leave this negotiation process, I have my rights outside court. But it is important for you to understand that even that party has that particular right to resort to courts or any other dispute resolution mechanism. So this is a dominant feature, parties use it, but this is not really effective because the other party has similar rights as you. There is nothing dominant about that. Power based is basically when you are resorting to violence or any kind of negative impact, which actually happens in real life as well. And, you know, you make threats, open threats to other parties that, you know, I will do this, I will do that. But in the end, these type of negotiations are not really the fruitful ones. The most important is a more collaborated and interest based approach where you think about the other party and, you know, generate solutions which are acceptable to both. Next slide. Dealing with difficult negotiators. Difficult negotiators are those who adopt point number 2 and 3 in the previous slide. They are dominant. They have certain characteristics such as open threats. They are way dominant from the start. They are not listening to you. It's very easy to detect difficult negotiators or hardball negotiators. And the key is to be patient with them. So a person can talk for ages, but if that person particularly thinks that the other party is not responding to my threats or my dominance, the person would stop immediately doing that. So that is a stage where you actually see where you are being held with confrontations, where people are not listening to you, where they are actually setting out boundaries, they are creating loads of obstacles in front of, you know, the mediation process. And they are, so in that case, it is very important for you to know that if there is a difficult negotiator or there is a hardball negotiator, but in the end, you are here for your client and for your interests here. So to extract that one or two solutions from both the parties to, you know, which would actually serve your interests, you should know your partner and partner very well. If you know that this is a difficult negotiator and settlement is not likely to be reached, you would know that this is my partner and this is the partner, so at least I can come to that and take something from the table. So by way of that, by way of effective bargaining, you can be calm, be prepared, be focused, and be blunt in there. So change your role accordingly to that particular person. If that person is being difficult, you be difficult. If that person is not responding to your answers, you do not respond. But you need to be aware that even if you are being that blunt to the difficult negotiator, he or she will exaggerate that further. So you need to, it's all about in the process, whatever happens, whatever party is dealing through, but the ultimate negotiator is the one who's actually thinking on the spot, adapting to a particular situation, adapting to the persons who are there opposite, and being calm, being patient, and talking about all those things and trying to understand why is that particular person being difficult. Because there are reasons behind people are being difficult, or they do a hardball negotiation. It is because either they have something to hide, they have done something wrong, or they are just scared of you. So these are just three things where these difficult negotiators come into picture. And if you be calm, be assertive, and be prepared for all of these, know your partner and partner well, you can still take something from the table even while dealing with a difficult negotiator. So in the end, what you need to adopt is a strategy wherein you identify your interests, the other party's interests, create options, focus more on fairness and relationship building, encourage effective communication, and talk to that person, let them talk, listen, effective listening, understanding what they are going through, making them understand what you are going through, separating that relationship from the problem, because that is the most important thing of a mediation, that you need to focus more on relationship building, and but in a way that you separate the problem from the relationship. So if there is a dispute between a wife and a husband, you need to separate your relationship from that and see what is the actual problem that you're dealing with to preserve that long-term relationship. So focusing on promises and commitments is one thing. Next slide. Now, giving a proper gist of what the ADR competitions involve. This was all about ADR negotiation and mediation, the possible approaches that you should have as a person. But when it comes to a mediation competition, you have, of course, two teams and you have two members, the client and the counsel. So basically there, understand this rule that there must be a 40 to 60% ratio when it comes to a negotiation pair. 40% of the talking is to be done by the counsel, and 60% of it is need to be done by the client, because it is ultimately the client's business. I have seen in competitions where counsels and clients are, counsels are speaking more than what the client should. That is, of course, up to you. But of course, in the end, it is what the client is going through. And you are the counsel. A counsel's duty is to talk about business, talk about numbers, talk about the technicalities to help the client. The expression of interest, the expression of the problems, the possible options and solutions is to be done by the client always. And taking the decisions is also in the hand of the client. It is just that you need to help your client to reach to that particular settlement. When there are negotiations going on as to the numbers, as to the reality checks, then the counsel comes into picture. So know the difference between being a counsel and, because since ultimately it's not your business in the end, it's your client's business. So you need to be aware as to protect your client, but make sure that your client is actually, his or her interests are being fulfilled. So know the difference, have proper team coordination. So from a client's perspective, it is also important for you to actually take care about your counsel, because use your counsel effectively as a client, because there might be situations where a numbers game is being played on, and there are huge numbers, huge money on hand. All of these situations are kept on the table, so you need to make use of your counsel in that particular way. Use your mediators well, because these mediators are the actual facilitators who actually help you. Because clearly, if you are in a mediation, your negotiation has failed and you actually appointed a neutral because you couldn't actually resolve your dispute by way of direct talking. So all of these things need to be considered while going through these competitions. And the stages are basically the opening statement that both the mediators give. The opening statements are followed by the client and counsel's opening statements. There comes the agenda setting phase. Agenda setting is basically you have 3 to 4 issues from both the parties' perspectives, and the mediators help you streamline those issues. And on the whiteboard, they actually jot them down in an organized manner and give them the way that this is one issue that you can discuss first, this is the second issue. So agenda setting is basically consisting of those issues and problems which they have arise in a very effective and efficient manner. The mediation process is, of course, consisting of a caucus and a joint caucus and a private caucus. The joint caucus is where the parties are actually all the 4 parties are there on the table along with their counsels, and the mediators are there, and all of them are actually taking care of the entire process. A private caucus is basically if a party doesn't want to share anything from and wants to have a confidential discussion, then the private caucus can be taken into picture. Closing statements are basically which come out in the end. Being a no settlement position or a settlement position, the closing statements are to be there because clearly parties are investing time and efforts in a competition, and in the end, it is always great to thank the mediators for their time, and your closing statements should be crisp and clear. So these are the basic stages that come into picture, and yeah, this is all about the ADR competitions and ADR in general. Of course, all the 10 slides that I have talked about today, these are pretty much relevant and applicable to how you conduct your competitions and how you do them, because there is no difference between a real life negotiation and a competition. All of these are very much same at hand. So yeah, if there are any questions, I am open to them.
Thank you so much, sir. If anyone has any questions, you can type it in the chat box and we will let sir know about that.
Participants, please feel free to ask your doubts.
So there are questions from participants. So should I read them to you one by one?
No, I can read them. It's fine.
Okay.
Way. So I'll just filter them on my own. So elaborating more on the role of a mediator. So second is how free are mediators when it comes to giving solutions? This is one question. Role of a counsel. Firstly, talking about the role of mediators and taking these 3 questions in hand when it comes to a mediator. The role of a mediator is a facilitator, and you cannot suggest things to parties. You can just suggest them the way forward and give them options that this is something you can try, this is how you can try, but you cannot suggest something. So that is against the mediation process, because you are a neutral and you cannot favor one party and suggest them these things. That is the role of an adjudication, wherein arbitration goes into picture. So mediator's role is basically to create a trust building environment, give your opening statements, ask them effective questions, help the parties to sort out their agendas, their issues, conduct good amount of private sessions or a joint session with the party wherein you are actually trying to understand what they want and how they want and making them reconcile by talking about all these things. So in any way, you shouldn't be a suggestive person, because mediators do not suggest anything. How do mediation arbitration competitions take place? Well, this is not relevant to this, but I'll explain it in a line. So mediation, arbitration, a MEDAV competition or a MEDAV in real life is very much same to this aspect. So you have 3 stages in an ADR process: negotiation, mediation, and arbitration. That's how usually goes in a contract. So if in a contract, there is a clause of arbitration, dispute resolution clause, in that particular clause, there are things mentioned such as if the parties have to make if the parties should attempt to resolve this dispute within a period of 7 days by way of negotiation. So if the parties fail to that, the parties can resort to mediation for a process of 1 month and try that process and then shift to arbitration. So it's actually dependent on the contract. So if the contract has that mediation arbitration clause, that's how everything is conducted in terms of the process and all those things. So MEDAB is not different. It's just that you conduct and participate in mediation first. And if you fail, then you resort to arbitration. If both the parties don't come to a conclusion and deny all the advices given by the mediator, what happens next? So that is a situation of an impasse when I talked about it. If there is a situation of impasse, what you can do is denying all the advices of the mediator does not come into picture, because a mediator shouldn't advise on anything or suggest anything. So basically, if there is a situation of impasse, what you can do is you can shift to another issue as I suggested and talk about that issue first, if the parties are not agreeing to that particular issue at hand. A mediation competition has two members, the counsel and client. So where does the mediator come in role? I have explained the concept of a mediator there. A mediator is a neutral party, and he or she is very much independent of the party's role. Should the agenda's demands be included in the opening statement? Agenda is something that the mediators actually set out after listening to your interests. So in your opening statement, you need to, of course, lay down your interests, that these are my interests today, and this is something I want from this negotiation. So both the negotiating parties in their opening statement should make clear that this is my interest and these are the issues that I want to discuss. When you say interests and issues, these things are to be noted by the mediators while setting the agenda. To what extent can facts be made up in a mediation competition? You cannot make any kind of facts, or you cannot lie. You need to stick by your mediation problem, whatever is there. You need to stick to your confidential information, whatever is there, because the judges are actually reading the problem and reading everything out there. You cannot lie, you cannot make any kind of new facts. Whatever is there, you need to stick on that. A little percentage of 5 to 10%, you can, while sticking to the problem, you can say assume facts, but in that way, you need to stick to that particular situation. So you need to be very smart when you are actually assuming one or two things and saying it, but you should not divert from the problem. You should always stick to the problem. That is the most important thing. Any more questions? So if there is a pandemic situation going on, of course, these are things you can assume that pandemic was going on and all of that. But for that, the problem should have that issue of pandemic. The problem should actually mention that because of the pandemic, there was a delay on the part of my obligations towards this particular contract. And because of the pandemic, I couldn't complete the contract. But you cannot actually assume any other thing that because if there is nothing mentioned in the problem about the pandemic, you cannot actually say that there was a pandemic. So you can't lie on that perspective. I'll wait for 2-3 minutes if there are more questions. The idea is to stick to your problem in the end, because whatever you have in terms of a general information or a confidential information, that is something you need to stick to that. What is the role of a mediator in a private caucus? The role of a mediator in a private caucus is to generate as much information as possible that you cannot do in a joint session, because parties sometimes are not comfortable in those sessions, and there is a reason why a private caucus is taken. So a private caucus can be taken by the parties themselves, or even the mediator can actually request the parties to enter into a private caucus when he or she feels that, a party is being hesitant or not sharing enough information, because in the end, it is the role of the mediator to make the parties reconcile. So you can request a private caucus from the parties, or you can actually, even the parties can actually talk about taking a private caucus, and there you ask the questions because there the other party is not there. Only one party is there in a private caucus. So you can extract as much information as possible, but you cannot disclose whatever you heard in the private caucus without the permission of the other party. That needs to be noted. What should client include in the opening statement? The client should include everything relevant to that particular problem at hand that concerns that particular person. So you talk about your storyline in brief, what has made you reach the mediation table, why were there possible situations, what were the issues, what were the problems that were going on through your end and through the other party's perspective, what are your interests today, what are you here for, and what do you expect out of this mediation process, and what do you expect from the other party. That needs to be conveyed very clear from a particular party, from a particular client. And the council's opening statement should involve basically all the interests in the streamlined manner, that this is what my client has, and what the client talks about is the problem and the issues, but what the interests are of the client, that should be demonstrated by the counsel in his or her opening statement. So that is a distinction. In the client's opening statement, you only talk about the problems and you talk about the issues, you talk about whatever's been through. But in terms of the counsel's opening statement, you clearly talk about business there. So you talk about the interests, what you'll say, my client wants these things, and these needs to be put into the agenda setting phase. There is, I'm not too sure what confusion is there between a party and a council. There is no right to appointment of a council. If I am a party and Kanak is a party, and we are opposite parties today, okay? So I appoint Riddhi as my counsel on my own because I know her. She's been my counsel for my company's counsel, or my counsel for ages. I know her, so I trust her. There is no right to appointment. You just bring up any counsel. In the parties, of course, there is mention that this is the counsel and this is the client, but there is no right there. You just take your own counsel, whom you think he or she can help me win that particular negotiation. Kanak will get his or her counsel. There is no right to appointment here. Both the roles are very different. Yeah, so legal representative, I mean, this is the counsel only, a legal representative who's actually assisting the client. And, because in the end, the role of the counsel is not limited to the negotiation. After the mediation process is over, when you settle onto certain things and a settlement agreement is being written by the mediator, the counsels from both the parties sit with the mediator to write that settlement agreement and negotiate on the technicalities. So for instance, if Kanak and me, we today agree that, you will pay me some amount of money and you will have specific performance, but it is Riddhi who will assist the mediator and negotiate with Kanak's counsel that how that specific performance of the contract will be taken into picture, how will the money be given, in what kind of installments, by what amount of, how should be the mode of all these. So when the settlement agreement comes into picture, the councils actually sit together and decide how this needs to be done. An opening statement of the mediator should involve, firstly, you should actually involve the process. Firstly, you introduce yourself and the parties. You talk about what your role is. Third, you talk about the mediation process. You explain them the caucuses, you explain them the joint sessions. You explain your authority as a facilitator and not as a adjudicator. And you explain all these 4 concepts there in the opening statement. With the problem we have been provided, how do we evaluate as to we are on what side of the situation? So you will be given the roles of a requesting or a responding party as per the mediation problem. I guess the organizers will give it to you a day before, or whenever they give you, you will be aware about it. So Riddhi can take this question basically. When are you giving them the information?
So we will be providing them at least like 2-3 days before.
Yeah, so you guys will be aware as soon as possible. I mean, before the competition, there is no problem in that. But going by the mediation competition, both the parties will represent in 2 rounds at least. One side as a requesting party and one side as a responding party. So don't worry about that. Cool, Kanak, we can wrap up then. It's 5.
Thank you so much, sir. So, I, Kanak Batwal, on behalf of the team Law Internships, we would like to extend our heartfelt gratitude to Mr. Tushal Behr, sir, for taking out his precious time from his busy schedule and interacting with the young minds. It was truly an enriching experience workshop, sir. Thank you again.
Thank you so much. Thanks a lot for having me.
Thank you so much, sir. It was a wonderful workshop.
Thanks, Riddhi. Thanks a lot. Bye-bye.
Thank you, dear participants.